Welcome back to the Emily Show. I can't believe that we are at the last Wednesday show of the Emily Show. From here on out, it's going to be on Monday. We'll talk about that a little bit more later. Why? Because we got to talk about Alec Murdaugh. And yes, there's more still going on in the Diddy case. If I am starting to sound put out, there's just so many filings. I feel like I've become a full-time Diddy legal researcher at this point. And honestly, there's other stuff going on, but we have not had time. I have not had time because it's so many motions. And he has a court hearing coming up this week, so we need to talk about it. So you know what to expect when you see the court rulings start to roll out from that hearing this week. So with that, let's get into all of it. Welcome to the Emily Show. I'm Emily D. Baker, the internet's go-to legal analyst and big fan of the cursey words. I've been a licensed attorney for over 17 years. I'm a former prosecutor, and I break down the legal side of pop culture and entertainment stories we can't stop talking about. We should just get into it. Let's go. Thank you to our sponsor, Thrive Causemetics, for making sure I get out of the house relatively on time and with an eye look that I always love. The Thrive Causemetics Brilliant Eye Brightener are my entire vibe for everything I do. They come in more than 25 buildable shades, so you can get the eye look that you are wanting, and it's as easy as crayons, and literally that's what I need. I keep it simple, and it washes off so lovely at the end of the day, but it doesn't budge while I'm wearing it. My go-to everyday eye look right now is Muna on the outside of my eyes with Stella, which is a little bit of a champagne shimmer towards the inside of my eyes, and it is absolutely my favorite. But for a night out, Thrive has added a matte black, which I love for an easy smoky look. And don't forget, there is a sharpener at the bottom of your Brilliant Eye Brightener, which makes it so easy to keep in good shape. And if you really want to make sure nothing's moving, they recently added the waterproof eyeshadow stick. So you can choose your own adventure on that. But you know what I do have for you? A discount, because even though you know when you're shopping with Thrive Causemetics, you are purchasing luxury cosmetics that give back, you can also give yourself a bit of a break with an exclusive 20% off your first order at thrivecosmetics.com/Lawnard. That's Thrive Causemetics, CAUSEMETICS.com/Lawnard. And be sure to get 20% off your first order. All right, let's get back to today's episode. I know, before we talk about Diddy, we just have to talk about Alec Murdaugh. Why? Well, it's been a minute. We talked a little bit about his co-conspirator, Russell Laffitte, who recently had his conviction in federal court overturned due to an issue with a juror. And Alec Murdaugh is hoping for the same thing. He just filed the full appeal with the South Carolina Supreme Court because they agreed to take up the case. And let's do a quick road so far. It's been a minute since we've talked about Alec Murdaugh. It's been a minute since we talked about his appeal. And today we're not going to deep dive into all 50 pages of his appeal, but we're going to do an overview. His team did argue for extended page limits because they are arguing it is really two appeals in one because they are appealing on two very distinct grounds. We'll talk about it. But for those of you that may remember, I started covering Alec Murdaugh when there was what is now called the roadside shooting incident. It might have been called such at the time, but by the time we got to trial, that's what it was referred to, where it seemed that a prominent South Carolina attorney had been shot in the head on the side of the road. And then very quickly it came out that that looked like a insurance scam, suicide for hire situation. And then after that, he was disbarred. It came to light that he was stealing from his law firm, though people had been pulling that thread for a long time before it literally all cracked open, including Mandy Matney there in South Carolina, who was reporting on this on the Murdaugh Murders podcast, now the True Sunlight podcast. But those threads had been getting pulled before it all just unraveled. And then he got charged with the murder of his wife and son, subsequently convicted of that murder after trial. After the 3-week trial that morphed into 7 weeks of trial with just a delightful judge and a lot of local quirks in that courtroom that I covered live day by day over on YouTube. And that's part of why there is a shift to the podcast format and the day that the podcast drops, moving more towards the quicker updates on a Monday episode and then live streams on Tuesday, Wednesday, Thursday, Because when I looked at the trial schedule for 2025, there's literally no way we can do it all, or at least I can't. And live trial coverage is one of my favorite things. And there's going to be a lot of it in this coming year. So I wanted to make sure there was adequate time for me to, sleep. Things that are very dearly important to me. Spend time with the kiddos, spend time with the husband, see my family, and sleep. With that, this trial had gone from 3 weeks, morphed to 7 weeks with the financial fraud all right there in the middle of it. And after the conviction, there were very quickly rumblings from the defense team and then filings from the defense team that the clerk of court, Courthouse Becky, yes, her name is Becky Hill. Yes, I've been calling her Courthouse Becky on this channel since I went through all of her emails that were subject to a Public Records Act because she was signing a lot of them XOXO Becky Boo. Courthouse Becky is accused of interacting improperly with the jurors. This came up on a motion for new trial. It was heard not by the sitting judge of the trial, but by a former South Carolina Supreme Court Justice, Justice Toll. And at that hearing, the jurors came in one by one and talked about whether or not they had had any outside interaction, meaning did the clerk of court talk to them? Did she talk to them about the case? And did that influence their opinion? And you might be sitting there going, wait a second, I didn't follow all the Murdaugh stuff, but I'm following what's going on in Massachusetts with the Karen Reed case. And there is a whole fight over interviewing the jurors. And Emily, you're sitting here telling me that in South Carolina, they just literally interviewed all the jurors. Yes, because the standard is very clear when it comes to outside influence. Outside influence in the jury is very different than what we are dealing with in Massachusetts and whether or not that jury may have reached verdicts and did not memorialize them onto paper. Though it might seem insignificant, it is a legally very significant difference because the law is well tread in the area of outside interference. What the defense has been arguing since the motion for a new trial is that the standard South Carolina is applying is not the proper standard because it's pushing the burden back on to the defendant, saying that the defendant has to prove that outside influence when it is a state actor is something that prejudiced the jury versus the prejudice to the jury being assumed when an outside actor from the state interceded and spoke to the jurors. This comes up in case law, often with bailiffs, and that's a lot of the case law that was cited by the defense. So this all came up in a motion for new trial. There was a hearing in front of the justice. All of the jurors who remembered any interaction with Courthouse Becky indicated that anything she said did not impact their jury verdicts except for one. And that juror said, yes, they were impacted by what Courthouse Becky said to them, but upon further questioning said, no, it did not impact their verdict. So a lot of the fight on this appeal is whether or not South Carolina is going to adopt a different standard, a standard where the conversation is the problem and prejudice to the verdict is presumed. We saw conversations in the realm of people being impacted by things and not necessarily knowing that they're impacted by them a lot in the Brian Kohberger case in Idaho, where we saw the polling companies and the psychologists come in and talk about the fact that sometimes humans are influenced by something and they don't think that they are. And when you delve a little deeper, you will find that influence may be buried under the surface because people want to think that we can be impartial and we want to think that we can put it aside. And we often mean to, but sometimes our brains don't work that way. And that's something that they talked about quite a lot in the Kohberger case in those hearings about whether or not the change of venue would be moved due to the media covering this case in the area. So again, as we're talking about, can someone put it aside? Did it impact them? It's hard to say in hindsight what may or may not have impacted you if it was more subtle versus a more direct, like, oh God, well, now I think this clearly impact. And we've talked a lot about the Sarah Boone case because it's the most recent trial I live streamed. There was a moment in that trial that very much impacted me as the state started playing videos that the defendant had taken during the rebuttal case. I can look at that point in the trial and be like, that's what impacted me. I, at that point, was like, well, it's going to be real hard to keep an open mind after those videos in the rebuttal case. And when we got to the end of evidence, I was like, those videos changed how I saw this case as the evidence was coming in. as I think it did for the jury and for those watching along for that trial. But that can be hard to do down the road when you've rendered a guilty verdict. Somebody's been sentenced to 2 life sentences in prison. And then you're sitting there going, did this impact me? Did this not impact me? And the weight of it, the courtroom they were in was incredibly grand. And you've got Justice Toll there and all the attorneys and a massive gallery of people staring at these jurors being like, what did Becky say to you? Did that change your mind? Because this is something. And that juror even came back with an affidavit from their own lawyer after the hearing and was like, wait, I need to clarify. And the judge is like, we're shutting this down. This is now in front of the South Carolina Supreme Court. I will link the videos where I covered those hearings with the jurors if you are interested in seeing the coverage of that and seeing what the jurors said for themselves, because this is one of the main grounds that the defense is appealing on. They are appealing in this case on 2 grounds. So as I was pulling this up, I realized that I had pulled up the opening brief before when I said it was 57 pages. What I meant was 132 pages. That is what I meant. What I meant was that their filing from December 10th, 2024 was in fact 132 pages. So quick asterisk addendum on that. But we're going to go take a look at what the heart of the arguments from the defense are in this appeal. So as we are taking a look at the outline of their argument and their table of contents, their first argument grounds are that Murdaugh was denied his constitutional right to a fair trial by an impartial jury free from outside influence. They say that there is an irrebuttable presumption of prejudice when a state official secretly advocates a guilty verdict in the jury room during a criminal trial. This is their argument that the state Supreme Court should change the case law in South Carolina so that it is not a presumption that can be rebutted by the state, but that prejudice is presumed when a state official mucks with a jury. That is what they are advocating for, is this change of law. Justice Toll applied the law as it stands today and said, maybe those above my pay grade will change the law. But as it is today, the standard that South Carolina applies is that the presumption can be rebutted. So the defense does not have an easier time of it if a state official interferes with a jury. If that is a presumption of prejudice that cannot be rebutted, then it is a much easier road for Murdaugh. And if the state of South Carolina changes that presumption, this could result in a new trial, because then the fact that the jury was talked to, which was established at the hearing, the fact that they were talked to then becomes prejudice is presumed, not prejudice must be proven and can be rebutted by the state. So it changes the circumstance if the law changes. They go on to outline that argument, saying that the United States Supreme Court holds that in a criminal case, jury tampering is presumptively prejudicial. That is what they want. That is their strongest argument. And they want South Carolina to adopt that position. They go on to say the presumption of prejudice is irrebuttable when a state official tampers with a jury during a criminal trial about the merits of the case, and that the state cannot rebut the presumption of prejudice by arguing Ms. Hill's jury tampering was harmless because secret advocacy for a guilty verdict in the jury room during a criminal trial by a state official is a structural error in the trial that cannot be harmless. Let's take a look at what they're saying that Courthouse Becky did. Not surprisingly, the Russell Lafitte or Lafayette case is being referenced here, where the defense says the Fourth Circuit very recently made a similar point when overturning a Murdaugh-related criminal conviction. Notice how they tie it together but don't say co-conspirator. The defense attorneys have picked their words wisely. They say a Murdaugh-related criminal conviction because of a violation of the defendant's Sixth Amendment right to trial by an impartial jury. In that case, the Fourth Circuit held that the trial court's removal of a juror during deliberations violated the defendant's right to an impartial jury because there was a reasonable possibility that the removal was related to the juror's views on the merits of the case. I talked about that in a live stream that will be linked if you want to go check out those arguments. They were saying that in that case, like in this case, the government was arguing that the violation was harmless, and here the defense is arguing against that in asking the court to adopt a new standard. They go on to say this case, however, is distinct from the Lafayette case in that Ms. Hill's, and I will use Lafayette and Lafitte interchangeable. Lafitte just feels more disrespectful, and sometimes disrespect is due. If you are not aware of the Russell Lafitte case, go check it out. He was one of the bankers at Palmetto State Bank that worked with Alec Murdaugh as he was stealing money from clients who were the most in need after catastrophic injury cases. So it goes on to say that this case is distinct from the Lafitte case in that Ms. Hill's jury tampering is so far beyond the pale that the court should have no reason to be reluctant to conclude that her conduct constitutes structural error in the trial. The issue here is not whether the judge erred in dealing with a jury issue during trial, nor whether a juror engaged in misconduct, nor whether some member of the public engaged in misconduct, nor whether a defendant engaged in misconduct, nor even whether a bailiff made an improper statement. The issue is whether an elected state official, and Clerk of Court is elected, using the power of her office to enter the jury room during trial to advocate against the defendant to promote her own financial interest. Remember the book deal? Which wasn't really a book deal because it was self-published, but go with me. Is a structural error in the conduct under the trial, under the principle that all evidence and argument presented to the jury must be presented in the courtroom. They go on to say the undisputed evidence and findings from the evidentiary hearing are that Ms. Hill did engage in jury tampering. 3 jurors and the alternate juror testified that Ms. Hill made comments to them regarding the merits of Murdaugh's testimony in his own defense. I mean, I made a lot of comments about that if you watch the trial, but we weren't talking to the jury. What are you doing, Becky Hill? This could undermine this entire trial. It goes on to say one juror and the alternate testified that she told them not to be, quote, fooled by the defense, which is wild. They go on to say the only witness to contradict any of the testimony was Miss Hill, whom the trial court found to not be credible. Oh yeah, she did. Justice Toll was having none of it. It goes on to say one juror even testified that Miss Hill's conduct did influence her decision to vote guilty. That juror did walk that back, though. Under more questioning, that juror walked that statement back. They go on to say Miss Hill's conduct would necessarily bias a jury against the defendant. It was an abuse of discretion for the trial court instead to reason that it does not matter whether that happened because any jury, biased or unbiased, would reach the same verdict in this case. And then we get to one of my favorite parts of this because they are citing law from 1807. And yes, they are citing it from Burr's trial. And if you just said to yourself, are you Aaron Burr, sir? Yes, that A. Burr. They are talking about the concept of trial by jury and trial by an impartial jury. And they say the principle is ancient and foundational to our system of trial by jury. In the ultimate analysis, only the jury can strip a man of his liberty or his life. In the language of Lord Coke, a juror must be as, quote, indifferent as he stands unsworn. His verdict must be based upon the evidence developed at the trial. This is true regardless of the heinousness of the crime charged, the apparent guilt of the offender, or the station in life which he occupies. It is so written into our law as early as 1807 by Chief Justice Marshall in 1 Burr's trial 416, 1807. Yes, that's a key site to the trial of Aaron Burr. And if we need to do a breakdown of the trial of Aaron Burr at some point when we are not in trial on current cases, we can Hamilton some old school law. If you're interested, you're going to have to let me know. Am I still singing Hamilton in my head? Yep, I am. If any of you put in the comments right now, speak less, listen more, it's never going to happen. It's never going to happen on this channel. It's commentary. If podcasting had been around when I was a kid, they would be like, okay, you just start a podcast and tell someone else. I did. It just wasn't around then because I'm old. The defense goes on to talk quite a lot about Juror Z, the juror who said that they were influenced by Becky Hill's conversation about Alec Murdaugh and then seemed to walk that back. And the defense argues again that the testimony of Juror Z was not ambivalent, that Justice Toll identifying it as ambivalent, they say is unsupported by any evidence in the record. And they say when asked, quote, was your verdict influenced in any way by the communications of the clerk of court in this case? She answered, yes, ma'am. When asked, and how was it influenced? She answered, to me, it felt like she made it seem like he was already guilty. When asked, did that affect your finding of guilt in this case? She answered, yes, ma'am. But she later said, which is removed from this, that she would have voted guilty based on the evidence, not on what Becky Hill said. And that's where I think we're going to see the state criticizing this argument. The defense also made sure to air out everything Justice Toll, and in this case, remember, former Chief Justice Toll was sitting as the trial court instead of Judge Newman, who recused himself off of this matter for the hearing on the motion for new trial and the hearings with the jurors. So this is Justice Toll as the trial court. And the defense quotes, at the conclusion of the hearing, the trial court ruled from the bench, "Did Clerk of Court Hill make any comments to any juror which expressed her opinion what the verdict would be? Ms. Hill denies doing so, and so the question becomes, was her denial credible? I find that the Clerk of Court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed that as early as November 2022, long before the trial began. She denies that this is so, but I find that she stated to the Clerk of Court, Rhonda McEvan, and others her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified, and she made some of those comments before he testified to at least one and maybe more jurors. The Clerk of Court allowed public attention of the moment to overcome her duty." They also say, when they quote it elsewhere in the motion, that Ms. Hill was attracted by the siren call of celebrity. And that is one of the lines that I remember most from Justice Toll ruling from the bench on this. So the main ground for appeal is the jury tampering by Clerk of Court Becky Hill. If the South Carolina Supreme Court decides to change the standard, and they decided to take this up directly, the Supreme Court does not have to do that. This could have gone through the courts of appeal and then gone to the state Supreme Court, but the state Supreme Court allowed this motion and this appeal on the denial of the motion for retrial on these grounds to be heard directly. That indicates to me that they want to evaluate this law, or they want to evaluate this case. And I think it's that they want to evaluate their standing case law, and it has not come up for them to evaluate it. Remember, without a case in controversy, the Supreme Court can't just say, well, that old case law is not what we're going to apply anymore. This does not come up this often, thankfully. But this might be one of their only opportunities to change the standard. And if they do decide to change the case law in South Carolina, it could very much overturn this verdict. The other grounds that they are appealing on is regarding error with character evidence. And during the trial, we talked about one of the concerns about letting in too much evidence of other shit can lead to an appellate court being like, well, what's the balance of them finding him guilty on the evidence at this trial? And what's the balance of them finding him guilty because the state has shown all of this other shit that goes to his bad character and other potentially bad acts and other things, not just the evidence in this case. And there is a fine balance between what is permissible and what is too much. And sometimes the trial court is like, well, this is reasonable. And the Court of Appeals or Supreme Court is like, no, not this time. So the other grounds relate to the character evidence. Those are all the evidence about the financial crimes. They argue about statements that came in. They argue about the court allowing a Charleston County deputy to provide evidence of unscientific experiment. And if you're sitting there going, Emily, I don't remember this trial that well. What's an unscientific experiment? He threw his phone. He threw a cell phone around his office to see if when it was tumbling through the air, the screen would alight or not. You had to be there. It was wild. And with no scientific methodology and with no Daubert hearing or not a very thorough Daubert hearing, it was wild testimony. Honestly, I don't think the Supreme Court's going to get this far because if the Supreme Court finds the Courthouse Becky issue is going to overturn this, the rest of the arguments in this 132-page brief are going to be moot. We will see how the state responds, but we can't talk about Murdaugh without talking about what is going on with Courthouse Becky because that shit's not done either. A huge thank you to today's sponsor, Green Chef, for keeping me out of grocery store parking lots during the holidays. What I don't need is to be running around the grocery store trying to make sure that my family eats a balanced meal. Instead, I just have those balanced meals delivered right to me. And Green Chef makes it so easy because you can pick from a wide variety of eating preferences and number of meals. 2 meals per day, 4 meals per day, or more? Do you want protein packed or completely vegetarian? Are you looking for gluten-free or just balanced meals? So why not have chef-created meals with easy-to-follow recipes, pre-measured and prepared ingredients sent right to your door? So yes, you can just chop some veggies, feel like you cooked, and have a delicious meal ready to go in just about 30 minutes. And what I love is that I can plan a month's worth of meals in advance on the Green Chef app. And if I ever need to go in and change it, I can, but I can also set it and forget it. You know who's wishing they could get Green Chef meals for dinner? Well, probably Diddy and Alec Murdaugh, but you can with today's offer at greenchef.com/EmilyBaker50. Use code EmilyBaker50 for 50% off your first box plus 20% off your next 2 months. That's code EmilyBaker50 at greenchef.com/EmilyBaker50 for 50% off your first month plus 20% off your next 2 months. Find out for yourself why Green Chef is the #1 meal kit for eating well. Let's get back to today's episode. So you may remember my coverage of the 76 ethics violation that the State Ethics Commission was looking into with regard to Courthouse Becky and her handling of her duties and taxpayer money as the Clerk of Court, because they laid it all out. That was supposed to go to hearing December 19th, this week. However, on October 31st, the State Ethics Commission granted a request to hold the ethics investigation in abeyance in perpetuity. So it's going to just be pending. Why, you may ask? Emily, why, when there are 76 ethics violation of Courthouse Becky using taxpayer monies to do all kinds of shit like throw parties and other things that are not what her role as the Clerk of Court is supposed to be, when she's allowing people to pay for tours and see the holding cell of where Alec Murdaugh was kept? All of these things, why aren't these going through to the Ethics Commission? Well, let's see what they have to say. This is from October 31st, 2024. Order granting respondents' motion to hold in abeyance the above captioned matter, and that is the state's Ethics Commission regarding Becky B. Hill. The above captioned matter was called for hearing on December 19th, 2024. Prior to the call of the case, months prior, respondents' counsel, Becky Boo's lawyer, moved to hold this matter in abeyance in light of a pending criminal investigation undertaken by the Attorney General's office. Commission staff stated no objection. This matter is hereby held in abeyance pending resolution of the criminal investigation. So we have heard rumblings about a criminal investigation being opened. We have now seen it in a court filing. So Attorney General's office for the state of South Carolina, I ask you one question, WTF? And is it a difficult position for the Attorney General's office to be arguing that Becky Hill's actions shouldn't overturn Murdaugh's trial, and then also be investigating some of those similar actions for criminal proceedings? I just wonder if maybe the Attorney General's office that is arguing against overturning the trial should maybe outsource the investigation into Becky Hill, who they rely on, and saying, look, she did the thing she did, but that shouldn't overturn the trial. I have concerns about them being in charge of both. And yes, offices are large and they can do different things, but criminally prosecuting Becky doesn't look good if you're arguing that she didn't impact your jury. Just my thoughts. Let me know what you think. And for those of you that love the live streams, we're going to be talking a little bit more about Alec Murdaugh on Thursday, because there are some other interesting side stages going on to all of this. Emily, are you saying they're playing the side stage at Coachella? Well, yes, perhaps. So don't forget to tune in on Thursday for the live stream to talk a little bit more about some of the tea going on surrounding the Murdaugh case. And if you followed that case, once we get into it, you're going to be like, nah, but we're going to have to wait. Make sure you download the Law Nerd app so you don't miss a live stream. And remember, next year, Tuesday, Wednesday, Thursday, all live streams. Same bad time, same bat channel. Let's do an overview of Diddy and his damn laptop and all the discovery and everything that's coming up for hearing, shall we? Diddy's lawyers have been incredibly busy in court, and they have a hearing scheduled for Wednesday, December 18th at 2 p.m. Eastern Time. And on that, there are a number of motions coming before the court. You will remember that one of the things they had moved for was Diddy to get his laptop. Diddy got his laptop. We'll look at that order from the judge in just a moment, and we'll talk about what he is being allowed to do with the laptop that he has and how he's being allowed to use it. And if you watch the Sarah Boone case and any of the pretrial motions, you'll know that she fought back and forth with the judge about when she could use a laptop, what was on the laptop, how she could access things on the laptop, how things were organized on the laptop. It's a whole thing. Yes, having access to a laptop in custody is a whole thing. There are also other motions pending with regard to the legal pads and whether those notes are legal, whether they're not legal, whether they're attorney-client privilege. And you will remember that I overviewed briefly that the defense is asking for a suppression of anything that the government learned because of those notes. And that includes fruit of the poisonous tree, which means if you learned this thing in the note and then you went and found other things, that those other things can be suppressed. Yes, there are exceptions to that in New York if it will inevitably be discovered or discovered by other means. So that's not necessarily how that will go, but there will be a lot more legal wrangling over what was in those notes, if they're attorney-client privileged, and then if they have tainted anything going down the road of the poisonous tree. They have asked for a special master to do a full privilege review. The judge might decide to do the privilege review. They might grant a special master. The judge has asked the taint team essentially to stop reviewing anything because they are part of the U.S. Attorney's Office. It's like you've reviewed what you've reviewed and you don't need to review any further. They are asking for a disqualification of prosecutors who may have been tainted by the information from the notebooks that they reviewed that was given to them by their taint team. They have asked that defendant stop being monitored in his communications with the defense team. That can be difficult because if there are defense investigators who are not lawyers, then if they call in on the public line, those communications will be monitored until they realize it's defense team related, and then they won't be. We'll see what happens there. And ultimately, the defense is asking again for a dismissal of the indictment. So that is still pending. The defense is also asking for a larger or expanded gag order, and they are trying to put a gag order on witnesses, victims, and anyone else who may be related to the case, including grand jury witnesses, because we have seen grand jury witnesses speak to the media after they testified. And the defense is like, can we please stop that? We've also seen them ask for a bill of particulars. That has not been ruled on yet, and that means they want the government to break everything down in more specificity. I don't think that's going to be granted. The government was pretty thorough in all of their motions about what this case is about, and we know a lot of what this is about is the Intercontinental Hotel video and things that happened between Diddy and Cassie that the defense keeps characterizing as a relationship. And this was a 10-year relationship and, it wasn't great. And then they just try to excoriate her and her character, which I am just not here for. The defense had also asked that the video from the Intercontinental Hotel be suppressed, and they made much fuss over whether or not that video was quote unquote leaked to the media. And I think in an attempt to limit the things that were going to be argued over in the hearing on Wednesday, Judge Subramanian ruled on that quote unquote leak motion regarding the video from the Intercontinental on December 16th. We're going to take a look at that real quick. Again, this is coming from December 16th, 2024. Defendant Sean Combs moves for discovery and an evidentiary hearing on alleged government leaks of case information. For the following reasons, the motion is denied. Combs alleges that the, quote, government, primarily through the Department of Homeland Security, has engaged in a 7-month campaign involving strategic leaks of grand jury material. Right now, the motion seeks discovery and an evidentiary hearing related to the alleged leaks, although Combs forecasts that he may ultimately ask for suppression of certain evidence or dismissal of the indictment, and he has done so in subsequent motions. It says, while Combs identifies numerous alleged leaks, the heart of his dispute with the government is regarding a 2016 video from the Intercontinental Hotel in Los Angeles that Combs alleges was leaked by the government to CNN. The judge goes on to state, as to searches of Combs's Combs, he argues that the presence of media on scene made it, quote, clear that DHS alerted the media prior to the search in order to maximize exposure. The court says, but of course the searches, which were executed pursuant to warrants, were not themselves, quote, matters occurring before the grand jury. They say Combs provides no basis to suggest that there have been any Rule 6E violations here with regard to the searches of the homes. That's not grand jury material. And again, LA's got people keeping eyes out. LA's a sneaky peeky area. So yeah, when they see the fucking SWAT team roll up to a home they know to be Sean Combs, somebody's calling all of the media and being like, this is a lot of police presence. Same with Miami out on Star Island. Like, that's not odd given the places he lives. It would be stranger if he lived off the grid in, Wyoming or Montana. It's not odd in Miami and LA. The court goes on to say, as to the Intercontinental Hotel, Combs has not carried his burden to show that the government leaked it to CNN. Combs argues that, quote, the most likely source of the leak is the government. But he doesn't point to any sound basis for this conclusion. Give me a moment to speculate. This is my speculation based on everything we've learned from these court documents. What we've learned from court documents that the defense has not refuted, not once, never said, no, that didn't happen. What the defense has not refuted is all of the allegations that Sean Combs, through people working to him, attempted to pay off those at the Intercontinental to disappear this video. And the reason he's fighting with the government over this video, in my speculation, is because he thought he successfully disappeared this video, paid the right people so this video would never see the light of day, and was destroyed. So this video coming to light, I think, was shocking to him because he paid for it never to come to light. The defense has never refuted that. They are so mad about this video, and it has been a huge focus. And I think that is a client-driven focus in this case. And the government has mentioned that Sean Combs, through his agents, through the RICO organization, paid people off to get rid of this video. So this is all coming from court documents, and it's been argued over thoroughly in multiple oral arguments and multiple motions, and the defense never once said that he didn't pay anyone off to get rid of the video. This defense team has never not once held back on accusing the government of shit. So if they could argue with a straight face that that wasn't true, you know that they would. The court goes on to say, after the court points out that Combs does not have any sound basis for the conclusion that the most likely source of leak was the government, he goes on to air out the argument saying, first, he argues, Combs, that federal agents have already engaged in a months-long campaign of leaking information to the press, and by May 2024, when the CNN video was leaked, and so they had a, quote, demonstrated propensity to make such leaks. Second, he says that, quote, victim one is not a likely source of the leak because there is no evidence she had access to the tape and she had no motive to approach law enforcement after receiving a, quote, substantial 8-figure settlement. Because they want to put that in every single motion. When this goes to trial, I wonder if a jury's like, it still wasn't enough. We don't care if she got an 8-figure settlement, still not enough. But they didn't say that he didn't try to get rid of the video. The court goes on to say, third, Combs surmises that an unrelated third party is not a likely source because such an individual would have sold the video instead of simply giving it to CNN. To Combs, the leak shows a motive other than financial profit to damage Mr. Combs' reputation without remuneration. Tell me you think you can buy your way out of everything without telling me you think you can buy your way out of everything in a legal filing. It goes on to say, and finally, Combs suggests that the timing of the leak points to a government source because, get this, federal agents would have known that May 17th was a perfect time due to a break in the Trump trial for Barron Trump's high school graduation. Yep. The suggestion that the leak was to CNN was during like a slow news day is wild. The court goes on to say, the government says that it obtained a copy of the video at the same time as everyone else when CNN released it. The government rightly points out that Combs, the court's like, stop it with me. Stop playing with me. They say the government rightly points out that Combs never considers the possibility that many people beyond victim one and the government agents likely had access to the video, including Combs's team, parentheses, who paid security officers at the Intercontinental Hotel $100,000 in cash to destroy the video, and the hotel employees and contractors. An ex parte submission by the government, which the court considers after an in-camera review, which is new information, presents compelling evidence that CNN's source was not, in fact, the government. The court goes on to say, and importantly, nothing in CNN's presentation of the video even hinted that the source was a government agent. And you know they would. It goes on to say, as to the interviews and quotes attributed to law enforcement agents, none discloses, quote, matters occurring before the grand jury. Combs doesn't identify a single article with government sources disclosing grand jury materials, despite telling the court that, quote, several of the leaks explicitly mention grand jury proceedings and the grand jury's ongoing investigation. The court goes on to say this is not well taken for another 2.5 pages and ultimately denying the motion in a very thorough order. The court also ordered that Diddy have access to the laptop, and I want to take a look at that with you real quick. Thank you to today's sponsor, Shopify. You've probably been seeing Shop Pay pop up all over the internet while you are doing your holiday shopping, whether it's for others or for you. I'm not going to tell. And Shop Pay makes it so easy as a customer to just go ahead and check out. And if you are a shop owner, it makes it super easy to just get paid by allowing your customers to check out using Shop Pay. It's no wonder that Shopify has the highest converting checkout on the internet. So whether you are looking for an e-commerce solution, you're looking to sell in person, or a combination of both, Shopify has you covered. So whether you are just getting started or you are moving your shop to the next level like we have with Laundered Shop 2.0, Shopify is there. And if you ever need anything, their customer service is easy to reach and they will walk you through it. It really is no wonder that businesses that grow with Shopify. So get ready to upgrade your checkout to the same one that the Laundered Shop uses with your $1 per month trial period at shopify.com/laundered. Remember, that's all lowercase. Head to shopify.com/laundered for your $1 per month trial period. That's shopify.com/laundered. And get ready to hear this sound soon. Let's get back to today's episode. This is a short order from December 12th, 2024, breaking down what access Diddy has to the laptop and the restrictions there. It says the court is in receipt of defendant's application regarding discovery laptop access and defendant's attorney visitation forms. Having reviewed the parties' submissions, the court orders as follows. 1. The MDC is ordered not to turn over defendant's attorney visitation forms to the government. So do not tell the government when his attorneys are visiting. Stop it. 2, the MDC is ordered to give defendant access to discovery laptop 7 days a week from 8 a.m. to 3:30 p.m. This can be in his unit's visiting room or in his unit's VTC room. So he has supervised access to it. And again, this discovery laptop is just discovery. No internet, no other programs, to review discovery only. And the court clarifies that more as well. The purpose of the discovery laptop is to review discovery, not to take or store notes. It is the court's understanding that the laptop has been preloaded with discovery materials, but does not allow any functionality beyond reviewing those materials. It's essentially an e-reader loaded with discovery, and the reason they don't do it on an e-reader is because there is video and photographic discovery that they need to play. And I don't know if it's actually a laptop or like an iPad tablet, but they refer to it as laptop, so digital device laptop. They go on to say if defendant wishes for broader access to the discovery laptop, his counsel should discuss it with the government, which should consider any reasonable proposals in good faith and work with the Bureau of Prisons, counsel, and MDC staff to effectuate them. If there are further disputes, the court will consider adjustments. So yes, Sean Combs got access to his discovery materials on a laptop. He cannot use that to communicate in any way. It is literally just for reviewing materials and locked out for all other purposes. The other things that are going to be happening at this hearing are the other pending motions, any discovery issues, and I think the court is going to regularly have these hearings with them We've already seen how mad the defense is over the legal notes. I think that'll probably be most of the hearing. I'll be following along for breakdowns of that hearing on Wednesday, and I will talk to you about what happened at the hearing, or at least anything of note in live stream on Thursday. And with that, Lawnerd, we are at the end of our Wednesday episodes of The Emily Show. And though we are shifting format coming in 2025 and shifting the length of the episodes and dropping them on Monday, which is called Quick Bits now, but will go forward as The Emily Show. So for all of you that listen on the audio feed, this is just a change of the drop day. And what you can expect on your favorite podcasting app going forward are the breakdowns that we've been sharing of the live streams when I am covering topic by topic, or summaries of trial when I am covering trial, and those will be on the audio feed throughout the rest of the week. What you can expect on the Emily D. Baker YouTube channel is live streams, all the live streams. Join me at 11 a.m. Tuesday, Wednesday, Thursday, and if we're in trial, join me at whatever time that trial starts, give or take 10 minutes, Monday through Friday. That's why we started the Lawnerd app, to keep you in the loop, because schedules do change. Court hearings do come up. Occasionally I forget to calendar stuff and go, oh, there's a hearing today. By the way, guys, we're going to cover this hearing today. May take 2 hours, may take 15 minutes, may take all day. Tune in. You never know. And then I keep you in the loop throughout the day on those longer court days so you don't miss the things you're interested in the most. This podcast started before I started covering law on YouTube. And the purpose of this podcast, way back on episode 1, was to use the stories in the news to teach people who are operating businesses about the law while I was still doing my consulting work. When consulting shifted when everything shifted, and I started breaking down pop culture cases on YouTube and started streaming, it was instant and immediate love. I have always loved this podcast, but being able to take it up a notch with more content weekly, being able to talk to you in real time is the thing that I love. Law is a conversation, and it's harder to have that conversation in the comments section than it is to have that conversation in real time in the chat. And when things happen, I'm going to be real honest with you. I am ADHD. Trying to wait to cover something for a day or 2 or 3 is not always easy, because I'm like, oh, you can't believe what just happened. I want to talk about it immediately. And live stream not only fills that immediacy for me, but it allows me to have that real-time conversation with you. And bringing more live streaming into 2025 felt like the right move all the way around. And I'm so excited about it. But I also didn't want to give up this podcast that I've built over the last 5 years that has topped the charts on Apple and Spotify, that has grown so well in the audio form and continues to grow on YouTube in the video and audio form. So if you are a YouTube watcher primarily, the episodes on Monday will all drop on my second YouTube channel, the Emily Baker Quick Bits channel. But again, if you have the app, it'll just drop in the app and you just click it and it takes you to the channel you watch it on. And those Monday episodes will stay in that same format of filling you in on the quicker stories, whether or not we're in trial, so that we can stay in the loop on all of the cases we have going on and summarize what's going on as best as I can when we are also doing trial coverage. And that channel will continue to have what's on the audio feed, the court summaries, the breakdowns, the trial summaries, so you can tune into the cases you care the most about, skip the ones that you don't, and really find the coverage in a way that works best for you, because that has always been the goal, while also getting to do what I love to do the most, which is talking to you about all the shit that's going on with the law. So from me, from our Wednesday episodes, it is a farewell to Wednesday, but not a goodbye. Look, this is episode 333 of the podcast. I absolutely love it. And though we are changing formats a little bit, it's not going anywhere, and I'm not going anywhere. I'm just going to be live more. And that's what I'm looking forward to in 2025. If you are a YouTube watcher, and so many of you are, there will be stuff on the audio feed throughout the break, but I am taking the winter holiday with my family to celebrate Christmas and the New Year, to have some downtime, to rebuild some of my office. I'm so excited to rebuild my desk. For those of you that follow me on social media and my app, You know that this is not the first time we have rebuilt a desk, but I'm very excited about it. So I'm going to take some downtime to reset so that we are ready for all of the trials to come and all of the law to come in 2025, because I love doing this. I love having these conversations with you. I love getting to be here. I hope that you do too. And so truly from the bottom of my heart, I hope that 2024, even if it's been a tough year, has been a way for you to connect with this community and connect with this law nerd community, no matter what has been going on in your year. And I've seen in the comments, those of you that have beaten cancer this year and gotten the all clear, those of you that have started that journey this year, watching along with me covering trial, those of you that have gotten accepted into graduate programs in law school and PhD programs, master's programs in nursing, and those of you that have just recently finished your PhD programs, law schools, that have passed the bar, that have become paralegals, that have become RNs, that have endeavored into new careers alongside the law nerds in the chat with you. For someone who is rarely at a loss for words, I truly don't have enough words to tell you how inspired I am by this community, how much it means to me, and how encouraging it is to see this community online thrive in a positive space, looking for the facts, not the fuckery, and having some laughs along the way. It truly is an incredible honor to get to be here with you. I can't wait to be here with you live even more. And though shifting the format of the podcast feels a little bit like a door closed, I really think it is just a chapter closed to open up a lot more live streaming and really accommodate a lot more trial coverage to come. Because man, oh man, we've got Keefe D, fingers crossed that it's televised in March. We got Karen Reed in April. We got Corey Richins in April. April's going to be busy. And then it looks like they're going to set Donna Adelson's trial right in the middle of the summer, because don't they always? So Donna Adelson will probably run us right up to the Kohberger case that is going to run from August to November optimistically. And there are going to be a lot of pretrial motions in between and a lot more cases to come, because there are cases I've been keeping an eye on that will be going to hearings and trial that we haven't even started to cover yet. So for all of you that have been reaching out about the cases you're keeping an eye on, don't worry, I'm keeping an eye on them too. I wanted to get caught up on what we've been covering. But hopefully when I come back here Monday, I'll be telling you that Tom Girardi's been sentenced to some prison for stealing from his clients. We're going to keep following the lawyer fuckery, and I will keep you in the loop on Mondays going forward. So don't forget to tune back in on the 23rd for some programming updates and an update on the Girardi sentencing. And with that, law nerds, have a very, very happy holidays, a great new year. Stay safe. Thank you for being here. Thank you for being a law nerd. And as our format changes, so will our outro. So So say it with me one last time. May your Wi-Fi be strong. May your toilet paper be plentiful. May your families be well. And may the odds be ever in your favor. Thank you for being here, and I will see you soon. Bye. You can stay up to date with everything I'm covering on our free iOS and Android app at lawnerdapp.com, or search your app store for Law Nerd. And you can also follow me on social media at the Emily D. Baker. Remember, I stream on YouTube on Tuesdays and Thursdays. I recap all of that for you in quick bits on Monday. And of course, the Emily Show drops on Wednesdays. Thanks for being a Law Nerd.